All right, Richard, we have so much to discuss. I'm going to jump right in by one of the most striking of your claims, which you make throughout the book, but in particular in the conclusion. You say the central message of the classical liberal constitution is to go against the grain of modern Supreme Court jurisprudence and much of the legal scholarship that's grown around that body of work. And you also say repeatedly that conservative originalists have moved too far in embracing judicial restraint, and you question the deference that conservative justices and theorists show to democratic legislatures and call for a measure of principled judicial activism. Tell us more about that claim.
Yeah, I mean, one of the things that you have to deal with in constitutional law is to sometimes accept the proposition that the obvious propositions are true. And when you look at various kinds of constitutional provisions, particularly those which are contained in the Bill of Rights, many of them are drafted in very broad terms. Congress shall make no law abridging the freedom of speech, nor shall private property be taken for public use without just compensation. Now, the only way in which you can understand words like freedom and private property is to be able to figure out how they are used both as a matter of political theory and as a matter of common law, that is, general judicial interpretation. And private property, for example, is an all-embracing notion. So to say that you believe in the fidelity to text and that you believe in narrow interpretation essentially puts two ideas into tension with one another. You're not loyal to text on the one hand if you read it narrowly when the text is broad. And so what you have to do is to figure out what it is that you do in order to keep the broad readings faithful. This creates a real problem in constitutional interpretation, because one of the things that are wrong with the originalism, particularly that associated with Justice Scalia, is that often he thinks that the Constitution text is self-contained. But in fact, going back to Roman times, and I should tell you, one of my deep areas of academic involvement for over 40 years is I'm perhaps the last living American Roman law professor who teaches this subject full time, is that the Roman interpretation strategies took provisions like this, and they said, you know, we realize that they're not self-contained, that if we have a prohibition against taking private property, well, we better have a prohibition against blowing it up, even though we may not take the pieces, and that leads to the law of inverse condemnation. It means you can never take private property, even when somebody has a gun at your head, you can't disarm them. Or you can take private property. How do you measure compensation when it's supposed to be just? So there's this whole elaborate body of non-textual stuff that has to be read in, and that stuff essentially goes traditionally under the name of the police power, narrowly understood, where every major constitutional prohibition is subject to exceptions for health, safety, morals, and general welfare under the traditional formulation. And you have to explicate all of those terms as well. And so the project becomes extremely hard. There's one further difficulty I'll mention and then take on after this. Is unfortunately, interpretation is a human activity. Many times it's done by people who don't quite get it right. And what you then have to do is, if you go on the first wrong step, you keep going down that path, or do you try to correct it? And in many cases, the thing to do is to essentially ratify earlier errors on the grounds that they've helped the Constitution survive as an active political entity. So to give you just two illustrations, the general rules on judicial review, that is, can the Supreme Court overrule statutes of Congress, and general review on judicial review over the states, it seems pretty clear if you're a close textualist, it could do neither of those two things. We could not run America that way. So in addition to being able to go beyond the text in a static sense, you also have to be able to incorporate what I call the prescriptive Constitution. That is, those changes that have become so ingrained in the American fabric that it becomes impossible to get rid of them. Just the way when you look at land law, there's a theory of prescription or adverse possession, which says that repeated trespasses stop things that are wrongs and turn them into rights.